All right, good morning, everybody. Thanks for joining us. My name is Tanner Watt. I'm a municipal program specialist with LAS. I cover the group buying program for Southern Ontario. I'm joined by a couple of my colleagues. We've got Raman Kabra, who is general counsel for the group buying program. She works with RMA, primarily, Rural Municipalities of Alberta. They are the administrative lead for certain parts of our program. And take on some of the procurement work. So that's where Raman is the expert. And I've also got Tim Elms. He's the Northern Ontario rep for the group buying program. So any municipalities essentially north of Algonquin Park, if you have any questions, reach out to Tim. Any south of there, I'm your guy. We launched the group buying program about a year and a half ago. The goal was twofold. One was to decrease costs for the products and services that municipalities are using every day. And the other was to decrease the amount of time that municipalities need to spend on their procurement work. We know that that is a big part of what needs to happen. And a big time commitment for municipalities. So we're trying to smooth out that process as much as possible. A couple of housekeeping notes. We are recording this webinar and we'll have the video available on our website, and we will send it to any attendees in a follow-up email. And the Q&A we will do after the presentation, and we'll use the Q&A feature that's built into Zoom. So at the bottom of your screens, there's a Q&A box. If you have any questions that come up throughout the presentation, just type those in and we'll answer those at the end. We're hoping to, we'll be here for a good while after the presentation to answer questions and hope to have a bit of a conversation going with the attendees. So with that, I will hand it off to Raman.
Good morning, everyone. Today I'm here to provide just a legal and procurement update. And what I want to do is just go through a little bit about the legislation that's governing trade at the municipal level, and then just move into a bit of what we do at LAS and RMA to ensure that we're meeting these obligations, and so that there's an understanding of the obligations on municipalities and on buying groups to comply with certain rules and legislation, and then just the ways that we're doing that for you. So our reach, LAS, RMA, SARM, this is a group partnership here across the country, and we're able to provide services at a improved cost when we're dealing with such a large group. When we're looking at domestic trade in Canada, it's governed at various levels. So there's local legislation, directives, and policies that provide guidance to municipalities. Then there's the regional agreements that set out various partnerships that seek to remove barriers in trade. And then there's the national agreement that governs all of us, and that's the CFTA, and that's what I'm going to focus on today. But it is important to note that these agreements they overlap at national and regional levels, and none of these agreements operate in a vacuum. So when you're engaging in procurement in Canada, it's important to ensure that you're considering these different levels at all times. The legislation continues to grow and evolve given changing times. So it's important to keep that in mind. So just a bit of background. I mean, it's been almost 4 years since the CFTA has come into effect, but it's still fairly new. We're still learning a lot about the impact it's having on trade within Canada, and there's still a lot of education that needs to be provided on, the impact and the enforcement of the Canadian Free Trade Agreement. But what it did was it replaced the Agreement on Internal Trade, and that was the first pan-Canadian agreement on trade, but it only applied to certain sectors of government procurement. And it was great in theory, but in practice, provinces and municipalities just continued to operate as they did locally. So the goal of the Canadian Free Trade Agreement was to pick up where the agreement on internal trade left off to eliminate trade barriers to the free movement of persons, goods, services, and investments within Canada. Now, what it did was it provided a framework for internal trade that was more in line with provisions that we're seeing in regional agreements. So, for example, the Ontario-Quebec Cooperation Agreement. And it's a more comprehensive and modern framework for internal trade. There's a clear set of trade rules, and the goal is really just to being able to access opportunities across the country and achieve greater value from procurement. The signatories are the federal government, the provinces, and the territories. So as your province is a party to the CFTA, each respective province is responsible for ensuring compliance by its regional, local, and district and other forms of municipal government. So, what's the big deal with the CFTA? Well, really what it is the way we look at it is an expansion of regional trends of transparency and non-discrimination throughout the country. So many of the changes that you see are also intended to align with our European CETA and other international treaties as well. Less limited by competing interests of jurisdictions. What that's referring to is there wasn't a ton of agreement on the previous agreement on internal trade. So there wasn't as much commitment from the jurisdictions. There was more flexibility, and there was very generous interpretations provided to the language of the previous agreement. So the CFTA has, more agreement on goals, commitment from the parties, and it's more specific or rigid in its approach. There's also improvements to dispute resolution, and that's something we're not going to get into today because there's, that's a whole session on itself. But for us at LAS, it provided us with consideration of buying groups and group purchasing. And so that's something that we hadn't seen very much direct consideration of in trade agreements and policies prior to CFTA. So generally, CFTA is providing rules for government procurement, within the MASH sector. The values, it applies to goods and services for values exceeding 105,000 and about 264,000 when it comes to construction. Those values will continue to change. Every 2 years, there's an adjustment for inflation. So initially, in the last 4 years, it's gone up by, just about 5,000. Now, the CFTA has higher procurement thresholds than its regional counterparts. But when you're estimating valuation, it's a bit different. So as a municipality, you're required to include all taxes, fees, extras, as well as optional renewal years when you're calculating the valuation. So it's not just simply the initial term for which a commitment's been made. You need to include those additional expenses as well. So it's easier to hit that 105,000 target than initially considered. And then we've talked a bit about the provincial responsibility for compliance. The province is the signatory to the agreement, so they are responsible for ensuring compliance locally. And then positive obligations on buying group, I touched on that a little bit, but when we're talking about government procurement, we're talking about rules for procurement for a governmental purpose of a good or service that's not intended to be resold by any contractual means, and that includes purchase, leases, rentals, with or without the option to buy. And so that's what we're talking about when we're talking about these rules. So as a buying group, for LAS and RMA, we don't look at individual member procurement, but we look at the total procurement value. And so our offerings are always put to the open market and following CFTA rules. So there's no concern about whether or not those thresholds have been met. We assume, given the procurement value and the size of our group, that, that we're going to exceed those targets. So when we're talking about a buying group, it's fairly simple. It's a group of 2 or more members that combine their purchasing requirements and activities of the members into one joint procurement process. So this includes cooperative arrangements, and some more formal corporate arrangements in which the buying groups are administering procurement for the group members. And that's something that's more in line with what we're doing at LAS. So, buying groups can consist of a variety of entities, and it can include a combination of government entities, private sector, and not-for-profit organizations, but you're still going to be under this umbrella of the CFTA. Now, when it comes to buying groups, I'm just going to go over some of the language just to indicate that there's no wiggle room here. As a procuring entity, the language indicates that it uses shall. So that means, a procuring entity, a municipality, a local district is required to ensure that procurement is conducted, that when procurement is conducted through a buying group, it's carried out in a manner similar and consistent with the general government procurement rules. And so what buying groups are required to do is publish a notice for each procurement. And the notice is required to list the participating procuring entities and outline the potential for future entities to participate in procurement after a procurement instrument has been put in place. Now, as a procuring entity and as our members, you're required to publish a notice of participation with a buying group at least annually on one of the tendering websites or systems designated by Ontario. So that notice is required to direct potential suppliers or vendors to the buying group tendering process. That's required to be published provincially or nationally, depending on what your government sets out. And for Ontario, I believe that's MERX. So here's a notice of intention that we've put out, or it's an example of one that our members could use to indicate, participation with the LAS processes and programs. And so, you don't need to write this down or take any pictures. The LAS website also contains sample text that you can use as a member to indicate your intention to participate in LAS processes. And now, this is also directly from the legislation, which indicates that when a procuring entity has little or no control over the procurement process, it's not required to ensure that the procurement is consistent with this chapter. And so really what that means is that in those instances, those obligations fall on the buying group or on LAS or RMA. And I just want to note that as organizations, we also post notices of intention, as well as concurrently post offerings throughout the country, to allow access in the various jurisdictions and just ensure that notice is given to the marketplace that's fair and open. So when we're talking about the rules, they're fairly clear. They're the same rules that would apply to you. And the same themes that we see across trade legislation. So it's open, transparent, and non-discriminatory access to covered procurement by procuring entities. No favoritism. So there's, the way that that's defined is treatment that's no less favorable than the best treatment that the party accords to its own local goods and services and to suppliers. No avoidance. And what that's referring to is that a procuring entity shall not prepare, design, or otherwise structure procurement or select a valuation method or provide procurement requirements in order to avoid the obligations of the CFTA. So, in the past, parties may have divided quantities of goods or services to be procured in order to avoid complying with the open tendering process. So that's very clearly outlined that that's not permitted. And then with circumventing, no circumventing, it's, a procuring entity shall not use options, cancel a procurement, or modify an awarded contract to circumvent the obligations provided in the CFTA. So, and what's really clear is there's no favoritism of goods, services, or suppliers of a particular province or region, and that just helps with that open, transparent trade process. There are certain things that are exempted, and I just wanted to touch on that quickly. Any sort of form of assistance, grants, loans, fiscal incentives, that sort of thing, acquisition of rent or rental of land, existing buildings, certain financial services and procurement related to that, health and social services. So there are these general exceptions, and there's also territorial exceptions and exemptions. So it is important that when you're looking at that to just keep your eye on that and just ensure that, if you're relying on an exemption, ensure that it exists within the CFTA. So this is what we're looking at, and this is what's required when a tender goes out, or an RFP, as we refer to it within our program. You're required to include, the name and address of procuring entity, a description of the procurement, the nature and quantity of goods or services to be procured, a reference to Chapter 5, which is the government procurement section of the CFTA. If there are conditions for participation, they need to be included. A very important part of the RFP is the evaluation criteria, where you're required to include even methods of weighing, in instances where price is not the sole indicator. Of course, the deadline, we talk about that in a little bit, about it being a reasonable amount of time, ensuring that the RFP remains open. Technical specifications. Now, with technical specifications, it's important that it's not really set out in order to obstruct trade, but rather to provide an indication of performance and function, rather than dictating a specific design or characteristics. Negotiation allowance. So if there's going to be an opportunity for negotiation with vendors, that needs to be clearly indicated. Negotiation is also allowed in instances where there's no clearly advantageous tender. And then the list of participants and the option of expanded procurement. So that needs to all be provided. And that's something that we at LAS do. We include, an Excel spreadsheet of entities that are participating and that may participate, so that it's not avoiding or preventing any certain vendors from responding to certain opportunities. Now, when you're looking at conditions for participation, there's a certain level of protection that an entity is, able to consider when issuing and setting out those conditions. The way that the Act describes it is that it just can't be something that's arbitrary or unjustifiable. So, there's going to be instances where there's preference for a local supplier or local service provider, given confidence in relationships. But, in those kind of instances, there's an ability to include requirements for having a local agent or setting some sort of bond or security if there's concerns. But otherwise, it's definitely not arbitrary conditions for participation. Modifications, clarification, and new info. All suppliers need to be informed when there's any sort of modification to the offering. Questions come up, so we usually advise our members if they're doing their own private procurement to post any sort of questions and responses that are given so that it's fair to all potential interested parties. And, if it's appropriate, if it changes, any sort of modification changes the ability to respond, extending the date of submission is something that is recommended. And when you're looking at time periods, the only guidance that's given in the legislation is that it be reasonable. So, you want to consider the nature and complexity of the offering, whether any subcontracting is anticipated, and time that may be required to transmit tender documentation by non-electronic means. So consider parties that may be mailing in their documentation. And we talked about this as well, just about negotiating. So it's important to set that out within your RFP. If, when there are eliminations to the award, or certain vendors, it just needs to be in accordance with the criteria that's set out. And then it's noted, you need to note whether negotiations will be concurrent versus consecutive. So if all parties will have an ability to update or modify their offers at the same time or following each other. So sometimes parties will set a deadline for negotiations to conclude for all vendors within a certain stage, and then proceed from there. And again, when negotiating, no unfair discrimination or advantages being provided to any one vendor or supplier. Standing offers, that's something that we use a lot within our program. And what's required, it is permitted, and what's required is noting that the competitive process is being put out there to establish a standing arrangement. And in your own RFP documents, you're required to describe how call-ups or orders will be made. We often put, because our program is voluntary, that it's at the discretion of members and future potential members, but there may be other nuances to, how an order or a purchase be made under a standing offer. Limited tendering, this is often referred to as sole sourcing or direct buying. It is permitted under the legislation, but in very narrow circumstances. I'm sorry, there's a bit of noise in the background here, so I'm hoping it's not overwhelming to you all. So limited tendering, so when there's no submissions that conform to the requirements or no submissions at all, that's permitted. If there's a need for a particular supplier and there's no reasonable alternative, unforeseen or emergency circumstances, we've seen that occur, with respect to cyber breaches and that sort of thing, where there's not enough time to conduct the RFP process. And then for IT procurements, there's a new exception that permits limited tendering for additional goods and services that were not initially included. And that's, going for limited tendering in the case where there's economic or technical reasons or an inconvenience or duplication of costs. So, that can be considered. Instances of collusion is a new exception as well. So if bids in a procurement process appear to be collusive, a procuring entity may choose to engage in a direct award. And of course, you see that happen sometimes in certain industries. So that is another instance where limited tendering is available. Other than these exceptions, they can, there's other ones that can vary from region to region. So definitely check the schedules to the CFTA and just note that. So for awards, so tenders need to be awarded within 72 days of the closing date of the offering. and you're required to, there needs to be compliance with essential requirements and conditions. So wording is very important in your RFPs. So where you have anything that indicates a must or a shall, those are items that, basically end up being a pass or fail. And if those items aren't there, those essential requirements, that vendor needs to be eliminated from the competition. You're required to pick the most advantageous tender or RFP response. There's obviously a public interest angle there as well, so unless it's not in the public interest. And if there's an abnormally low tender, you're able to verify that, within the market, you get an indication of pricing and that sort of thing. So if there's something that's abnormally low and there's concerns about, prices changing or once the tender is awarded, that price gets, like they shoot up the price or something happens there, you can verify how that pricing is being provided. And transparency with awards is important as well. So you're required to promptly inform parties of your decision. And if it's requested in writing, you're required to provide that in writing. Reasons can be provided on request as well. And vendor debriefs is a new part of the CFTA. So if it's requested, you're required to provide that. Award information is required to be published as well. So sometimes I get asked, what are inconsistent actions or, actions that would violate the CFTA? Well, preference for local goods, services, or suppliers, scheduling events within the tendering process in order to prevent certain suppliers from submitting tenders, using price discounts or preferential margins in order to favor certain suppliers or vendors, limiting participation in the procurement process to only suppliers or previously successful vendors. That's a new inconsistent action that's noted within the legislation. Prior experience is an interesting one. Usually, in RFPs, there's points awarded towards experience. You can only really require that if it's essential to meet the requirements of procurement. And so there are a number of instances where prior experience will be required, but there's also a number of ones where now that it's considered an inconsistent action. Providing information as an advantage. So anything that goes out, that's why when there's a question that's asked by a specific supplier or vendor, it's important to put out notices so that same information is being shared to all interested parties, because to avoid having this unfair advantage. And then creating unnecessary obstacles for participation in the procurement. And when we're talking about that, there are exclusions out there, for bankruptcies or false declarations, serious crimes and that sort of thing. So it's not that you're not protected as a procuring entity to look into those things or protect your municipality or your membership against those types of things. Now, there is potential for change to the CFTA. It is a fairly new piece of legislation, so there's still certain items that are noted within the legislation that are still required to be met. Provinces are, required to engage in sort of exploratory discussions and negotiations, about the inclusion of potentially including financial services into the CFTA. So I know that in Alberta, some of those discussions have not occurred yet. Things have been put off, of course, given the state of the world right now. But that is something that we might see some more additional changes. We may see the rules expanding to certain industries that are currently exempt. Certain provinces are removing any sort of exceptions to participation to promote business. So we see that happening. Now, There's also a requirement for the Government of Canada to develop an electronic single point of access. And so that's going to be great because it'll be a single access portal for all provinces, territories, and federal government tenders. Under the CETA agreement, the free trade agreement with Europe, there's a requirement that that be established by 2022. And I recently had a discussion with a member who's on the panel, and it's looking that that deadline's likely to be met. And then there's obviously potential for change when there's changes in government and policy. And as we learn more about the effect of these types of rules and enforcement of certain rules, that often changes our interpretation. So as a member, just as some tips, don't assume that your current practices are compliant. Take a look and make sure that you're meeting the different legislative requirements. I know that for some of our members, there were some existing agreements that were always sort of grandfathered in, and no one who was at that municipality knew when this agreement came into effect or what sort of process had taken place, because it was 30, 40 years ago, and it's just always the way things have been done. So just don't assume that your current practices are compliant. I always recommend to stick to lower thresholds to ensure compliance. So when you have the regional agreements, if you're conducting a private procurement process, take a look at your regional agreements. Those thresholds are almost always lower. So, it's better to be safe in those instances. Use caution when using any of the exceptions, ensure that they actually apply to you. And definitely use caution when developing conditions for participation, because that's the area where we often see the favoritism or discrimination type aspects of the CFTA come into play. And then definitely, if contract negotiations are desired, make sure you're specifying that in your procurement documentation. So there's a lot to consider under the legislation, and that's part of, one of the reasons why what we do is so valuable to our members. So we have reviewed trade legislation and guides across Canada, and that involves, a relationship with a national law firm to review and consider the various aspects as we continue to expand and grow. I have a binder in my office that, sets out the different provinces and agreements and thresholds. And so we've been doing that work already. We've met with officials to review procedures and processes. And so we have, a number of provincial approvals, for our national group, that our processes are compliant with the requirements of the CFTA. And we continue to update our templates and our contracts. As we grow, we know that there's changes that need to be made. And so it is an evolving process that we continue to put resources to. And we recognize that for our members, there's, time and resources are limited. So that's something that we're able to provide on our end. And like, I showed earlier, the reach of the group is significant. And we know that with that comes, the responsibility to continue to evolve and adapt to the various legislation that's in play. And we continue to respond. And it's a focus of ours to ensure that our programs aren't open to challenge. And so that's why we do what we do and continue to make changes to keep up to date with developments that may affect our members. And so when we're talking about revisions to our documents, various factors go into that, and it's a balance, just ensuring compliance while still ensuring access to the markets for vendors and the best processes for our members. So growth is a major factor. That's one of the reasons we've had those in-depth external comparisons done to ensure that our documents are compliant across different provinces. Environment plays a role as well. In the past few years prior to the pandemic, we saw most governments working towards reducing barriers to trade within Canada. But now, in the face of the pandemic and downturns in the economy, there's, some whispers that, some of these commitments will be pulled back on. But I do want to say that there was a meeting of senior officials in September. And so parties did affirm their commitment to the CFTA and this reduction in barriers within Canada. There's definitely a consideration that a healthy regulatory environment is also a significant part of economic recovery within the country. One of the things we've tried to do is remove ambiguity in our documents and our evaluation process so that our members are protected from challenge. So, sometimes when you take a look at our documents or our processes, it may seem fairly stringent. And the reason is that it's very valuable in the face of challenge. And I know that, there was a challenge to a procurement process last year. And so we were able to respond with our documents just to confirm that our commitment to the open process and just having that there was the end of the process. The complaint didn't proceed to the next stage because it was very clear in the language in our documents that certain requirements were necessary. So, we've managed challenges, over, the last couple of years. Our program is voluntary. And so, sometimes that can be a bit challenging because we'll see, our members be contacted by disgruntled or unsuccessful vendors trying to circumvent the process and go directly to a member to, avoid the procurement rules. And so that is very problematic. And if that's something that you're experiencing, please bring this to us and so that we can just further work to educate not just our members and the groups affected, but also vendors that may be experiencing this. It is a new landscape for many parties. And so, we're prepared to just continue to educate and help you in navigating those challenges. And, I just really can't stress enough the value of educating all levels, from the vendor side to the member side, just to create confidence in our programs and what we're doing. And we are confident in our processes and the benefits of our program. So, as we've seen in the past with potential challenges, our processes speak for themselves, and the benefits do trickle down to our members. And just as I've mentioned before, it's our position that, the strong processes result in strong relationships. So we continue to make changes, and we want to be able to do that to respond to the markets and the needs of our members. So we'll continue to do that. And that's an advantage that we provide as well. We want to do what we can at LAS to support our members in accessing, the best value for their procurements. And so managing compliance is a huge part of that. And so hopefully you all find that helpful. So just a kind of a reminder of the reach and the different associations that work together to ensure compliance across the country. And that's all I have for my formal presentation. So if we have any questions, I'm happy to take them. And I think Tim and Tanner are available to respond as well.
All right, thank you very much. That was great. That was a lot of good information. We're going to move over to the Q&A pretty quick. So if anybody joining has any questions, please type those in. But before we do that, I just wanted to make sure everybody was aware we do have a couple more webinars scheduled. So on April 7th, we'll be talking about modular bridges, which is part of the municipal group buying program. And on April 8th, we'll be doing an overview of our road and sidewalk assessment service. So if either of those are of interest, you can check out the events page on our website or respond to the email that I send out in the next day or two, and we'll provide more information on that. So with that, I'll hand it off to Tim for the Q&A.
Thanks, Tanner. Thanks, Roman. So as Tanner mentioned, we want to make sure that everybody's able to answer their questions. So if you would like, just write questions in the chat function at the bottom of the screen there. And I do have one question, Roman, and it is, are you required to offer tenders and bid in non-electric format?
No, there's not a requirement in the legislation. I'm sorry about this noise in the background, everyone. We have actually updated our RFPs to require submissions in a searchable electronic format. So it's absolutely not required. I think that there was a requirement in previous forms of legislation, just given the nature of certain industries, but it's not a requirement.
There's one more question here. I may have missed it, but is there any restrictions on piggybacking off of public entity procurements? For example, in Ontario, the province sets up vendors of records that are open to any broader public sector organizations to leverage. Would you like me to repeat that?
Yeah, please.
Oh, sorry. Okay, so it says, is there any restrictions on piggybacking off of other public entity procurements?
Right, so the restrictions there depend on the offering. So it would depend on the open process. So, we are required to list potential members or entities that would be procuring. So I would think that there is a limitation if certain entities were not included, because there's a bit of gray area with respect to that. But, it would really come down to taking a look at those procurement documents and seeing if you as a public body or municipality were considered in that offering.
So really low.
If you give me a second, I'm gonna just chat with the construction that's going on.
Okay, perfect. Yeah, it was kind of cutting.
I'll let you guys continue.
Sounds good. With that, yeah, looking at your specific procurement is important for sure. So those are some of the steps. So what you need to do is to review and update your organization's procurement policy to enable participation in the group programs. So.
Yep. And if you have looked at your purchasing bylaw and it doesn't allow for group buying or cooperative purchasing or however it's worded in there, feel free to send me an email. We have a document with some examples that we pulled from procurement bylaws across the province, and I can send that to you just to give an example of what that kind of wording would look like.
Absolutely. And I know Raman has mentioned this before. She's a great resource as well. So we have our contact here available. I'm sure Tanner will be sending that over afterwards and making sure that you can reach out to any one of us, and we'll be happy to make sure that we get the answers to you. Raman, it's way more quiet there.
You did a very good job. You answered all the questions.
You guys didn't hear me the screaming that I had to do to get this staff. No, we have great contractors. Just making some changes here, so he didn't realize that I was presenting next door.
I don't see any other questions coming through. However, if you feel more comfortable sending us an email, again, as mentioned, there's contacts you can reach out to us. Oh, actually, as I'm just speaking, there is another question coming in through. But yeah, as you can reach out to us after the fact, and we are going to be posting this. I know there's been some back and forth as well on our LAS website. So please feel free to look at that and draw on any information that you like from the video that will be posted. So I do have another question here, Raman. So one of the bullet points under the RFP slide indicates list of participants and potential for expanded procurement. Can you elaborate further on this? Does the latter refer to an adoption / piggybacking of the result agreement post-award?
Yeah, that's a great question. What we do is we include entities that aren't our members that like in areas in which we wish to expand. So we have contemplated future growth. So it's not, piggybacking is not really the correct term because we aren't anticipating that growth. We notice, we list members, existing members and potential future members, as well as provide a listing of, potentially impacted parties. So it wouldn't necessarily, I wouldn't refer to it as piggybacking because we are making it very clear that it's going to apply to certain, or may be accessed by other potential members, that may sign on later. So we've anticipated and built in for that growth. And that's something that, we spend quite a bit of time on. But if you take a look at our RFPs and the Excel spreadsheets that are provided, they're fairly detailed. So if you aren't a member of LAS or you haven't participated in our programs in the past, we have been including, a very wide scope of entities in our procurement so that it can be available to you. So I hope that answers that question.
Perfect. There's one more question here, and Raman, I'm so glad you're part of the presentation, so I'm going to defer to you. Although it's part of the capital purchasing program that we have through LAS. So this question is, LAS previously advised that they are also representing the U.S. buying group Sourcewell. Can you elaborate further how that would work to, again, piggyback through LAS instead of working with Sourcewell directly? And what are the benefits of going through LAS?
Okay.
You to answer that, but I'd like you to answer it.
Yeah, so we do have a partnership with Sourcewell, and the benefit of going, Sourcewell works with us to ensure that they're being compliant as well. And again, the way that our processes work now, where we concurrently post offerings, I wouldn't really refer to it as piggybacking, but it's very similar. LAS posts a notice of intention every year so that there's, an indication of opportunities available through the Sourcewell program. That's noted on RIRCs annually and on the website, as well, concurrently posting items. So that's what we do. There's a note there. LAS posts all Sourcewell RFPs, and that's Sourcewell, Sourcewell's, like the benefit to Sourcewell of our partnership is so that we can concurrently post and that we do access the members directly and within, this Canadian framework that's required. So by co-posting, we're putting that notice of that open, transparent procurement out there on behalf of the members, and we leverage the benefits from the simple purchasing power of Sourcewell. So that's how it trickles down, and that's what the benefit really is to LAS members. Do you have anything to add, Tim?
Well, yeah, you did a way better job than I did. That was great. I will just add that LAS on the website, las.on.ca, there's a great resource there where you can pull up all the vendors and pull up the documents as well, the link. It's right on the landing page. You click on the trade programs, and then from there, the vendors are all available, listed through a search engine. I know Tanner's been working really hard on that, and Jeff as well. And it looks great, and it's easy to use, and everything's there just to grab with links to all the documentation as well. So feel free to use that.
Yeah, and a couple more advantages of doing the Sourcewell contracts through LAS. One of the main ones is that if anything comes up, you have myself or Tim that are very easy to get access to. We know the local area a bit better than somebody in the US does. So you've got that local connection to provide support. And as well, not every Sourcewell contract is part of the LAS program. So there is kind of a secondary selection process, a vetting process that they go through just to make sure that they are ready for the Canadian market, that they have the support systems in place. So if you buy a piece of equipment through a Sourcewell contract from a vendor that's listed there, that you can get parts for it and have repairs done to it. All of that, that important behind the scenes work is done by LAS, just to make sure everything is ready to go specifically for the Canadian and Ontario markets.
Yeah, and to add to that, like there's instances where Sourcewell has had a program, but LAS has put out its own offering, just simply because of benefits to the members. So definitely there's a weeding out process in terms of what's going to be the most beneficial to our membership, and how we can best leverage the resources that we have.
I don't see any other questions come through here. Give it a minute.
And I will just add, like, it's been interesting with our relationship with Sourcewell, just, as we continue to evolve and grow. And I know I've kind of said that so many times today, but, we've established this relationship to ensure that their processes are compliant as well. So we have this mutual relationship where we confirm and work through, sort of the obligations on their end as well, because they're just not as informed on our market.
All right. So
no further questions.
Yeah, seeing no further questions coming in, I think we'll wrap it up there. If anybody watching has any questions that they would like to they either think of later or would prefer to have a more private conversation about, by all means, feel free to reach out to any one of the three of us on here. We'll be happy to help you out. Thank you very much for everybody for attending. Thanks, Tim and Raman, for joining us. Tim,
Sorry to jump in.
Yeah.
One more question, actually. So.
Oh, okay. I missed.
In the 11th hour.
Yeah.
When you indicated the preparation of a list of participants, potential participants, do you need to project the requirements for these in the RFP or not?
So I think the requirements, meaning I'm guessing that the reference is quantity.
It looks like participants and potential participants.
Right. Right, but can you just read it one more time, Tim?
When you indicate the preparation of a list of participants, potential participants, do you need to project the requirements for these in the RFP or not?
So yes to that. Yeah, and then when it comes to quantity, our program is voluntary. So we do note, we anticipate certain volumes, but we don't guarantee any sort of volume at all. Great. All right. Well, let's see the participants slowly logging off.
Yeah, I think so. All right. Thanks everybody for joining. We will all hopefully see a few of you again soon in a couple of weeks. I'll send out an email in the next day or two with some follow-up information, and we hope to hear from everybody again soon. Thanks, everybody.
Take care.
Take care.